How to get your student loans discharged in bankruptcy, Federal Student Loan Edition. I've talked about getting student loans discharged in bankruptcy and the undue hardship standard in the past, but today we're going to focus on the process that the Department of Justice uses to handle federal student loans owned by the U.S. government. Under normal circumstances, you would need to file and serve an adversary proceeding, which is a lawsuit within your bankruptcy case against the government. As with any other federal lawsuit, the government would get a limited time to file and serve an answer. From there, the court would set pretrial deadlines and a trial date. The parties would engage in discovery, hold depositions, and if they couldn't settle, they would conduct a full-blown trial in the bankruptcy court. But many borrowers couldn't afford to hire a lawyer and spend the money that was required on expert witnesses, trial preparation, and everything else that goes into a lawsuit of this magnitude. At the same time, the government and the courts were also being squeezed for time and resources. So in November 2022, the Biden administration issued guidance to streamline the process. The government now uses something called an attestation to review your case. If you meet certain pre-approved criteria, you can receive a partial or a full discharge of your federal student loans without the time and the high cost of that full litigation. The same legal standard remains in place, but this new procedure is less expensive, faster, and easier for everyone involved. So here's how it works. First, you file a complaint in the bankruptcy court to discharge your student loans under the undue hardship standard. Next, you serve the summons and complaint in accordance with the federal rules of bankruptcy procedure. Now, here's where things change. Instead of filing and serving an answer, the U.S. Attorney reviews your federal student loan account history, loan details, and educational history, and you also submit a completed attestation. This is a lengthy document that requires detailed information on your income, your expenses, future circumstances, and your previous efforts to repay the loans. Along with this attestation, you may be required to provide documents to back up the information that you provide. The government will then evaluate the attestation and your documents to see if you meet the legal standard for undue hardship. If you meet one of the presumptive criteria, the U.S. Attorney recommends either a full or a partial discharge of your loans. Now, a lawsuit that used to cost tens of thousands of dollars and significant uncertainty can be resolved in a few months and at a fairly modest cost. This process applies to all federal student loans owned by the Department of Education, Stafford, Grad Plus, Parent Plus, and consolidation loans. It doesn't apply to private loans. It doesn't apply to the older federally guaranteed FFEL loans, and it doesn't apply to any state-based student loans. We're going to talk about those in other videos. And yes, I represent people in student loan discharge cases nationwide. The evaluation is part of my regular planning session, and if you feel like you want help with your federal student loans, your private student loans, or any other type of debt at all, get in touch. You know where to find me.